The title of this paper is Using Dispute Resolution Provision in Contracts in Dealing with Business Disputes. Dispute resolution involves the use of a mechanism or more than one mechanism to resolve a dispute between parties. And these dispute mechanisms can in various forms. The known forms of dispute resolution are negotiation, mediation, or arbitration. A dispute resolution provision is an integral part of a business contract and is referred to in court action. However, failure to incorporate it in the contract does not affect its legality. The objectives of this paper is to study the use of a dispute resolution provision in regulating the way of resolving these business disputes. Commonly, without a dispute resolution provision, parties in dispute will refer their case in a court of law, and it is up to the court to decide on the fates of the parties after hearing their disputes. The study's specific objectives are to firstly identify the general contents of the dispute resolution clause, secondly, to analyze the effects of invoking a dispute resolution provision at the pre-litigation phase, and lastly, to analyze the effects of invoking a dispute resolution provision at the initial litigation stage. Okay, this study employs a qualitative study which relies on document analysis of library-based materials. It involves the analysis of text systematically from printed and electronic sources where the data will be analyzed and interpreted. A doctrinal study mostly used in legal studies is also employed, whereby crucial data from primary sources were extracted from the Rules of Court 2012, relevant acts and enactments. Secondary data were obtained from journal articles, proceeding papers, newspaper reports, and other relevant electronic materials. Okay, what should be included in a dispute resolution provision? Firstly, the agreed form of dispute resolution. Like what I have mentioned before, there are many forms of dispute resolution mechanisms such as negotiation, arbitration, or mediation. Secondly, the parties should choose a venue convenient to both of them. For example, the Asian International Arbitration Center, or the parties can even choose any of their disputants of their office as the forum of convenience for them to resolve their disputes. Then they should also decide how a chosen dispute is to be resolved by way of a chosen dispute resolution mechanism. For example, the parties should attempt to agree upon the appointment of a mediator. Okay. Should the parties fail to agree on the appointment of a mediator within a specified time, either party may, upon giving notice to the other, apply to the president or the vice president for the appointment of a mediator. The following slides will show you the many types or contents of a dispute resolution clause. For example, the catch-all dispute resolution clause requires parties to attempt the following. Firstly, the parties will try to resolve disputes through negotiation between senior executives of the parties or given the authority to settle the same. Okay, secondly, if the negotiation is not resolved within a timeline, then the parties can use an agreed alternative dispute resolution procedure to resolve their disputes. So these ADR procedures are such as mediation, arbitration, and negotiation. Another dispute resolution proceedings are such as suggested mediation and arbitration provision. Okay, the parties begin settlement discussion by referring their dispute to a mediator of their choice, as stated in a written notice to concur in such appointment. This is a sample where the parties agreed to refer to the Chartered Institute of Arbitrators. So in this instance, should the parties fail to agree within a specified timeline, either party upon giving notice may apply to the president or the vice president of the Chartered Institute of Arbitrators for the appointment of a mediator. Should the mediation fail, either party may, upon giving notice within a specified time, apply to the president or vice president for time being of the Chartered Institute of Arbitrators for the appointment of a single arbitrator for final resolution. Apart from the Chartered Institute Arbitrators, in Malaysia, we have the Malaysian International Mediation Centre. The key features of the settlement of disputes mediation consist of the following. Firstly, parties will refer their disputes to mediation prior to referring to any other forms of dispute resolution, including arbitration and or litigation. Secondly, any resolution reached in mediation shall be recorded in a settlement agreement, and the parties shall give effect to this agreement accordingly. Thirdly, a party may commence court proceedings without complying with the mediation clause or provision if the parties' claim may be time-barred under any provision of Limitation Act 1953 or any other legislation which imposes a time limit for bringing action, provided always that such party shall not object in the event the other party seeks to stay the whole or part of the proceedings for purposes of mediation. Now let us see what are the effects of invoking a dispute resolution provision at the pre-litigation phase. The pre-litigation phase is a phase where the parties have not filed the action in court. So in such an instance, there is always room for discussion. For the plaintiff, before filing an action in court, he needs to know whether there's a proper cause of action. Secondly, whether limitation periods have set in. Thirdly, whether there is sufficient evidence to back up his claim. And finally, the estimated litigation cost. The cause of action means the place where legal action can take place. It's simply a factual situation, the existence of which entitles a person to obtain from the court a remedy against another person. So, the effects of invoking a dispute resolution provision at the pre-litigation phase are as follows. Firstly, parties are more open to consider settlement or proposing a settlement. Secondly, parties may avoid unnecessary litigation and be more open to negotiation. Lastly, parties may avoid unnecessary expenditure and time spent on court action. Okay, let us see what are the effects of using the dispute resolution provision at the pre-litigation phase. It also helps to streamline the dispute resolution hearings or proceedings. For example, in an arbitration hearing, the parties will agree to specify undisputed facts and highlight the applicable law. This enables the arbitrator to rule on disputed matters summarily prior to hearing evidence. So parties are aware of the issues arising from disputes and concentrate on the best way to resolve them. So this ultimately will avoid them from bringing the action in court. The effects of invoking a dispute resolution provision at the initial litigation stage. Firstly, parties will take every step to ensure the existence of cause of action. Secondly, the claimant or would-be plaintiff will be encouraged to ensure that he can sue and there is indeed another person who can be sued in the capacity of a defendant. The plaintiff knows the consequence that if he fails to take this into consideration, his filing of action in a court will allow the defendant to strike out his claim under the provision of the Rules of Court 2012. In conclusion, a business dispute is inevitable for most businesses. However, an effective dispute resolution mechanism can reduce hostility and improve business relationship. Thus, the importance of a dispute resolution provision that can provide benefits that litigation can offer, especially when the parties are able to control the dispute resolution process. Thus, invoking a dispute resolution provision is necessary to encourage the parties to resolve their business disputes in an amicable way in order to preserve business relationship in the long run. In addition, it also allows the parties to reach an effective settlement plan for resolving their disputes via several dispute resolution mechanisms such as mediation and arbitration. Thank you for listening.